All right, it's April 9th. We had some rearranging of the schedule and providing a couple more minutes of time to all the folks that we have testifying today. And first up, we have the Attorney General's office.
Good morning. My name is Willa Farrell. I'm Court Diversion and Pretrial Services Director in the AG's office. And thank you for the opportunity to speak today a bit about our budget request as it relates to Act 180 and pre-charge diversion. Just a quick recap of history. Last year, the legislature passed what is Act 180 that codified pre-charge diversion statewide. And provided provisions about timely notification to victims and set other standards. It also placed pre-charge diversion under the Attorney General's office. Historically, what pre-charge has existed has been funded through Department of Corrections grants to community justice centers. But pre-charge has not been a statewide program in the way that actually provisions and codifies. The Attorney General's office proposed a budget. This is on the finals. Handout from our office. Proposed and rounding figures here 1.7 million to fund both existing providers as well as to roll out pre-charge statewide. Act 180 asked state's attorneys to develop pre-charge policies. So there's been a movement in that regard. And I know of in counties where there is not currently pre-charge diversion, state's attorneys and law enforcement officers, at least in some of those counties, have been asking their local provider, when will this happen? We would like to refer people to you directly. The reason for this interest in support, I think, speaks to the value of pre-charge. So I'll just do a little segue before we get back to the numbers. And that is the rapidity of the program. So law enforcement can refer people immediately. Restorative justice staff can reach out to victims and the person engaged, the person who committed the crime in a very fast, swift response. When there's timeliness of intervention, we know it's one of those important things of deterring future crime. It's also incredibly important for victims to get immediate support and availing themselves of existing resources, or just even to have the supportive person to process what happened. So the speed of pre-charge is really valuable. It is also, in this day, I think, a valuable resource for helping to address court backlogs. Those are cases that can get resolved without going to the state's attorney's office or into the court system. So for those pragmatic as well as more immediate personal benefits to people involved, there's a lot of growing support for pre-charge diversion around the state. Quickly back to the funding request, the House in its version of the budget included 1.1 million, which was the amount that when I say we, I did this in consultation with Marcy Harshin, our finance director, is the amount we project is needed to continue to fund pre-charge with where it exists now. And that figure was calculated based on DOC data and a portion of the grants that DOC funds community justice centers that are doing pre-charge. And then we project another 600,000 to roll pre-charge out for the rest of the state. So at this point, we're looking at a gap of about 600,000. Obviously, as I think everybody who's come before you acknowledge, these are really even more challenging times than budget. People developing budgets are dealing with, and so I guess I would say I want to advocate for what we need, and we will do the best we can. Any increase would certainly help us move this program forward into a statewide realm.
Which counties are asking to have services that don't have services?
Well, I can speak to Loyal County and Franklin County. Orleans County is another one. go through this. Addison County, Bennington, there's a lot of youth pre-charge that has not, that I think is the foundation for more growth from what I've been hearing. There's quite a bit of pre-charge in Caledonia, Essex, Chittenden a lot. Franklin, there's state's attorney there has spoken with me about his interest. And as is the case in Memorial, and program directors also had law enforcement approach them directly. Orleans, they have started to do a bit of pre-charge. You know, people are trying to find ways to fund it. And there's a lot happening in Washington and Wyndham. And I know that the Windsor County and Rutland County state's attorneys have developed policies as well.
So just to clarify, Memorial and Franklin, those are the only ones where the SA has asked to have it expanded.
Well, I can't speak directly because it may well be that I know in Orleans they have also. I don't know in Addison. So those are definitely 4 counties where I know state's attorneys are advocating for pre-charge. It may be that others are, and I haven't heard of it. Certainly other state's attorneys have developed policies, and that is a following the act.
Yeah, I'm all for expanding it in theory, but the only concern that I hold is when, you know, when the state's attorney has the discretion as to whether or not somebody can go into this program. And there's a huge disparity between one county and another where, you know, there, in my opinion, there are cases that should be going through the version and they would be in one county, but the discretion of the SA in the other county is different. And so, you know, you have these huge numbers. That's my thought. Sarah Bowski.
Have you done any analysis or can it be done, the savings to the system of investing this $1.7 million in diversion? Because I would imagine this is much less expensive than other alternatives.
It's definitely less expensive than cases going through the court system. I haven't done analysis specific to pre-charge, but we did have a study completed by Crime Research Group that looked at different types of cases that were handled through court diversion versus those handled through the court system. And you need to do this from memory.
Yeah.
That a case, example of a simple assault case handled in court diversion as post-charge diversion was about 15% of the cost had it gone through the full court system. So these alternatives are definitely less expensive than full court system.
Wonderful. Thank you. Because I do think it's, you know, as we're thinking about how to invest, it's important that we think about how we're smartly investing to, you know, it looks like $1.7 million today, but the return on investment for that. And I think that imagine there's also places we can't even measure. You know, we also know outcomes are better. People are less likely to recidivate. So there's all of these things that don't happen that cost the system by making this investment.
I do think the cost savings associated with low recidivism can be calculated by those who do that type of work, in that if a person doesn't commit another crime, you're then saving all those costs associated with prosecuting that crime, let alone the harm to any victim involved. So I would just like to go back, Shane, to your point that I think part of our rollout of pre-charge diversion has to include an assessment of readiness. So, you know, with the funding that the legislature appropriates, that is part of our process of making wise investments with the resources and determining, you know, where is there the most demand, and maybe that's where, frankly, I'm thinking about how do we do this if we don't get the full funding that we've requested. And so part of that, I think, has to entail a readiness assessment and prioritize where we roll out the program. But I remain very committed for this to be a statewide program. And I have seen in the past when the legislature creates opportunities that state's attorneys do embrace those and see the value of a tool.
Thanks. Any questions? Thank you.
Thank you.
I'll check on, the AG is slated to arrive at 9:30.
Okay, no problem.
I'll see if she's got. Staff.
You can go up, yeah.